Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. In this week's video, we're starting a brand new program, one of which I'm very excited to share with you, and one of which I'm very excited to bring to the profession for the very first time. And this has to do with combating bias in the medical legal evaluation that we as qualified medical evaluators are engaged in thousands of times throughout the state of California on a daily basis. Now, this topic of combating bias in the medical legal evaluation is going to be big news over the next several months and certainly over the next several years as the Division of Workers' Compensation enacts new legislation in the form of new QME regulations that have as their distinct purpose to wake up qualified medical evaluators and shake out from qualified medical evaluators their long-held stereotypes and biases, which we all have, and we're going to talk at great length about that in subsequent sessions, and to shake those out of us as qualified medical evaluators so that once and for all, we as qualified medical evaluators can provide opinions and conclusions in our reports which have the net effect of providing benefits for injured workers who so desperately need those benefits, so that we can provide opinions and conclusions and thus benefits for injured workers that are accurate. You see, it's our stereotypes and our biases that have the net effect in every single case of reducing benefits for injured workers who so desperately count on, rely on, and need those benefits in the case of a workplace injury. So it's been long known that stereotypes and biases that are held by qualified medical evaluators, through no fault of our own, by the way, these are stereotypes and biases that we were grown up with, that we've been indoctrinated with, that we've been surrounded with. But these biases and stereotypes impact other parties in the workers' compensation system in California, and specifically they adversely impact injured workers and the benefits that are provided to injured workers. So stereotypes and biases in the medical legal evaluation lead to inaccurate provision of benefits. Now, as we're going to see in upcoming sessions, there are many targets of bias and there are many types of bias that qualified medical evaluators have. So, for example, there can be biases against a particular claims payer. We can have biases against a particular applicant attorney or a defense attorney group. And we can have all kinds of biases that we can't even begin to scratch the surface of in this program. But this program is focused on bias related to injured workers and biases related to the types of injured workers that we see, the types of colors of injured workers that we see, the races of injured workers that we see, the genders of injured workers that we see. And this program is focused on bias related to the injured worker and the provision of injured worker benefits. So I'm very excited to share this program with you. And the purpose of this program, let's just go over this before we get into today's material. The purpose of this program is to explain to you how the DWC's plan to combat bias in the medical legal evaluation and bias in the reporting of QMEs, how that bias is expected to impact you as a QME, because this new direction being taken by the Division of Workers' Compensation is going to quickly envelop you. Trust me, this is going to envelop you all at once. Once these regulations pass, you're going to be swamped with new decisions and new considerations surrounding your biases and stereotypes. So if you can understand the Division of Workers' Compensation's plan and the intention of the Division of Workers' Compensation, we can then learn together, all as a group, moving forward from here, how we can arrive at opinions and conclusions, first of all, and then secondly, how we can write our reports, both of which are free from bias, so that appropriate benefits can be provided for all persons. Because, as I said earlier, biases and stereotypes in the medical legal evaluation lead to the provision of benefits, either too high, too low, that are not accurate. and all the parties in the system are demanding accuracy from the qualified medical evaluator. You know, no one in the system, no applicant attorney, no defense attorney, no claims administrator, no judge, no party in the workers' compensation system has any problem with accuracy. Accuracy is the sum total end game product for which we all as qualified medical evaluators need to strive, and in the future when these new regulations pass, we're going to be forced to demonstrate to the parties that our opinions and conclusions indeed are accurate because they are free of bias and stereotypes in those opinions and conclusions. So I'm very, very excited to share this program with you, and I have many, many topics to discuss with you. In today's discussion, I want to jump right into the history of the origin of the concern of the Division of Workers' Compensation and the history of the need to address bias in the medical legal evaluation. So let's begin this very, very important discussion by talking a little bit about the Paige versus Perry Soto lawsuit. Okay, and this was a lawsuit that was initiated in 2016, which brings us to the point where we are today. Okay, so let's begin, and we're talking about the Paige versus Perry Soto lawsuit, which was filed in Los Angeles Superior Court in 2016. I have this lawsuit right here. This is Paige versus Perry Soto, and this is a 46-page lawsuit, and I've included this in your course materials so that you can reference this lawsuit and so that you can read this lawsuit, and I recommend that you do read this perhaps a couple of times so that you can fully digest the philosophy of what the complaint of Paige, basically Paige and a few other claimants, what is their complaint and what is their problem that they're expressing, or what is the problem that they're identifying with the California workers' compensation system. So I have included this in your course materials. Now, the Paige versus Perry Soto lawsuit was brought about by a group of women. So this lawsuit concerns what Paige refers to as gender discrimination in the California workers' compensation system. Now, as we're going to see as we go throughout this course in this program, that the Division of Workers' Compensation is concerned about bias against all persons, all and any persons, and it's going to be targeting bias against gender, bias against race, bias against national origin, bias against religious preference, bias against sexual orientation, and all different types of bias. This particular lawsuit is related to gender bias. So just bear that in mind as we go through this lawsuit, but remember that the Division of Workers' Compensation is waging war against bias of all different types of targets in addition to the target of gender and gender bias. Okay? So Paige versus Perry Soto, that was filed in 2016, and it was this lawsuit, to the best of my knowledge, now I'm not an attorney, but to the best of my knowledge and based on my research, it was this lawsuit that served as the origin of the concern for bias in the medical legal evaluation, and it was this claimant, Paige, that had the courage to bring these faults with the workers' compensation system to the attention of the courts in an effort to reform the system, in an effort to remove discriminatory biases in the opinions and conclusions of us as qualified medical evaluators. So the allegation of the Paige versus Perry Soto lawsuit, and by the way, Perry Soto is, I believe, is the administrative director of the Division of Workers' Compensation. And Perry Soto wasn't the only party named in the lawsuit, but the lawsuit is referred to as Paige versus Perry Soto. So Paige alleged that California's system of workers' compensation perpetuates the type of overt sex discrimination that is a relic of a past era. It deprives women workers, so this is based on gender, women workers of fair compensation. So what do you glean from this already? Women were alleging that the bias in the California workers' compensation system provided for them, for injured women workers provided for them, reduced benefits, benefits that are not accurate, benefits that are not the same as those benefits provided to men with the same type of injury and the same similar circumstance. So it deprives women workers of fair compensation on the basis of stereotypes about gender and on women's reproductive biology. Okay, so this lawsuit alleged that women were being improperly and poorly treated by qualified medical evaluators who are mostly and largely male on a percentage basis, and that their benefits that they were being provided were unlawfully being reduced simply based on stereotypes that men, qualified medical evaluators, have about gender and about women's reproductive biology. And I'll share some examples, some actual examples from this lawsuit here in just a moment. Okay, and the lawyers that pled this case on behalf of Paige went on to elaborate about their allegation of gender bias and gender discrimination in the California workers' compensation system. And they explained that the workers' compensation system unlawfully discriminates on the basis of sex, in the calculation of permanent disability benefits, benefits which are intended to compensate injured workers for the long-term physical loss and the loss of earning capacity in two basic ways. Okay, so when we deal with physical loss, we're dealing with impairment and disabilities. So let's see how disability and impairment ratings for women fall short of those same ratings and benefits provided for men injured workers. So number one, they explained that women receive fewer permanent disability benefits than men, than the extent of their injuries merit, because harm, which is the harm that is unique to women, is ignored. Now, when we refer to permanent disability benefits, we know that permanent disability benefits are based in part on the permanent impairment ratings that are provided for by qualified medical evaluators. And these women in the lawsuit, Paige versus Perry Soto, alleged that the permanent impairment ratings, and if you remember the definition of impairment has to do with a loss of use or loss of function of a body part, body system, or body organ. And so those losses that are described by men are underestimated, are undervalued, are underreported and underrated because the extent of the harm, meaning the loss of function, the loss of use, because the impairment that is unique to women is ignored. And we'll explore some of the harms that are unique to women that are alleged and argued in this lawsuit here in just a moment. Further, so number one here deals with permanent impairment and permanent disability. Number two, as we're going to see, deals with apportionment. And they explain that the permanent disability benefits to which injured women workers are entitled are reduced through apportionment, that is, for no reason other than the worker's gender. Women's permanent disability benefits are routinely reduced because women's injuries are apportioned, that is, attributed in part to the risk factor or predisposing condition or pre-existing condition of the female gender, or due to women's reproductive biology, okay? And so, as we're going to see, being a woman is not a risk factor, being a female is not a pre-existing condition, and being a female is not in and of itself a lawful basis for apportionment in the California workers' compensation system. But according to Paige, and through the statistics that are cited by Paige in this lawsuit, for years and years and years, women have suffered lowered permanent disability benefits on the basis of apportionment to gender and on the basis of apportionment to issues and conditions related to their reproductive biology. Okay, so let's take a look at some of the allegations in the Paige versus Perry Soto lawsuit and look at some of the claimants involved in this particular lawsuit. Okay, so claimant number one in the Paige versus Perry Soto lawsuit was a woman who suffered industrial carpal tunnel syndrome as a result of repetitive motions at the workplace. And she received a rating for her carpal tunnel syndrome condition when she was found to be at maximum medical improvement. But the male qualified medical evaluator apportioned 20% of the impairment to non-industrial risk factors. In other words, related to the female gender. And he stated in his final report that 20% of the impairment due to carpal tunnel syndrome was related to the fact that the claimant was a woman, and that women frequently, especially women over age 50 and especially postmenopausal women, frequently encounter carpal tunnel syndrome, frequently develop carpal tunnel syndrome. Now, through no fault of her own, this claimant was female, and through no fault of her own, she was postmenopausal female, and through no fault of her own, she developed carpal tunnel syndrome, and the qualified medical evaluator took away or reduced her permanent disability benefits by 20% based on the fact that she was a woman. And the claimant argued that being a woman is not a risk factor, and being a woman through no fault of her own, through some situation that she had no control over and had no way to be able to influence, should not serve as a legal basis for a reduction in the permanent disability benefits. So this had to do with an apportionment, an unlawful apportionment allegation. Claimants 2 and 3 were both industrial breast cancer cases, and industrial breast cancer has a causative presumption for certain types of injured workers, certain types of workers. In both of these cases, these were public service workers. One was a police officer and one was a firefighter. They developed breast cancer. It was presumed to be industrial, and both of whom were evaluated by male qualified medical evaluators, who both found no impairment rating. No impairment rating. The first claimant had a double mastectomy. The second claimant had a single mastectomy, and because the AMA guides are very, very stingy on impairment rating for a single or double mastectomy, these qualified medical evaluators, in simply following the AMA guides, provided for low or no impairment rating for single and or double mastectomy, and these claimants argued that the permanent impairment rating was not accurate, that they indeed suffered many losses, many different types of losses, both physical and emotional, that were not described in the AMA guides, and that not only does the qualified medical evaluator, but also the AMA guides themselves unfairly discriminate on the basis of gender in the impairment ratings. So here we have an apportionment, an example of an apportionment, reduction in benefits based on gender. Here we have examples of permanent impairment ratings not accurate on the basis of gender. Finally, the fourth claimant was the California State Council. Now, the California State Council represents thousands and thousands of workers, many of whom are women workers, thousands of workers in various industry sectors throughout the state of California, and they filed a lawsuit as a group claiming and alleging that their members, their thousands of female members, are subjected to illegal reduction in workers' compensation benefits on account of their gender. So the California State Council pretty much mirrored the allegations of claimants 1 through 3, but they argued that this gender discrimination and bias against gender is affecting thousands and thousands of their members, and they provided some statistics in this lawsuit to support the allegation that thousands of their members are having their workers' compensation benefits unnecessarily, unlawfully, and unfairly reduced simply on the basis of biases and stereotypes related to genders, some of which have their origins in the AMA guides themselves. So let's take a look at the AMA guides and say what the AMA guides have to say about permanent impairment rating related to industrial breast cancer. Okay, so this is from the AMA guides, section 10.9, chapter 10, related to the endocrine system. Here's what the AMA guides have to say about the breasts. So a little bit of introductory information. The AMA guides tell us that the mammary glands make, store, and secrete milk. Okay, this is related to the mammary glands. And one may argue that the mammary glands themselves may not comprise the entirety of the breast and the significance of a breast, especially if you're talking to a woman. She may argue that there's much, much more to the breast than simply the mammary glands. But the AMA guides base their impairment ratings of breast issues, breast conditions, and mastectomy surgical procedures based upon the function, the impact on the mammary glands. So they tell us that the absence of the mammary glands does not cause impairment of the whole person in males. But in females, it will prevent nursing. So this certainly applies to premenopausal childbearing age females. It doesn't even attempt to consider women who have breast conditions that are postmenopausal or post-childbearing age, or who have no interest in nursing a child, okay? This only relates to women who are concerned with breastfeeding a child. They tell us that in some endocrine disorders there may be galactorrhea in females and gynecomastia in males. Gynecomastia in males may be accompanied by galactorrhea. So the AMA guides, to the extent that we can determine, are concerned only with the function of the mammary glands and are not concerned with the larger tissue in general of the breast tissue, especially as it relates to women who may not be involved in childbearing or breastfeeding. So here's how the impairment rating for breast conditions is evaluated under the AMA guides. This is found in Chapter 10, Section 9A. They tell us that a female of childbearing age, with absence of the breasts, or an individual with galactorrhea sufficient to require the use of the absorbent pads, and a male with painful gynecomastia that interferes with performance of activities of daily living. Okay, so 3 different types of conditions involving the mammary glands. Each would have 0 to 5% impairment of the whole person. So it tells us that a female with absence of the breasts, so that would be, for example, analogous with a double mastectomy or a single mastectomy, of childbearing age, by the way. So a female, let's say a 35-year-old female with a double mastectomy, would have 0% to 5% impairment of the whole person. Now, what if this woman is not of the childbearing age? What if this woman is a 50-year-old woman who's postmenopausal and never had children, never did breastfeed, never was interested in breastfeeding? That person would have 0% impairment according to the AMA guides. And in the Paige versus Perry Soto lawsuit that involved women with single mastectomy and double mastectomy, they argued that these impairment ratings in the AMA guides, which are applied by us as qualified medical evaluators, are not accurate because they do not consider the losses beyond the losses of function associated with the mammary glands. These women contend that their harms, their losses that are unique to themselves being women due to loss of the mammary glands is not adequately discussed in the AMA guides and was not adequately considered by the qualified medical evaluators who had the responsibility of providing impairment ratings that were accurate for these women. And so these women brought this lawsuit to the Superior Court of California and brought it to the attention of the Division of Workers' Compensation and demanded reform of the system, demanded reform in the sense that bias related to gender and bias related to women's reproductive biology be removed from the provision of benefits to, in this case, women. So Paige and the other three claimants, including the California State Council, brought this lawsuit to Superior Court of California in 2016. And after deliberation for just a very short period of time, in 2017, the California Superior Court issued what they referred to as a ruling of Demure. Now, I'm not a lawyer, so I'm not exactly sure what that means, but it's legal terminology. And I have that for you here. This is the ruling of Demure, as it says right here. And in the ruling of Demure, the Los Angeles Superior Court ruled that Superior Court does not have jurisdiction over matters that should be administered by the Workers' Compensation Appeals Board. Now, even though the Paige versus Perry Soto lawsuit was very thorough, very eloquently argued, very well supported, including statistics from the California State Council, and you should read this. I provided this for you in your course materials. Even though that lawsuit was very expertly prepared, it was prepared and presented in a court, which was the Los Angeles Superior Court, in a court that did not have the jurisdiction to rule or opine, even opine on matters, and that rather these matters needed to be addressed directly to the governing body for workers' compensation, which is the Workers' Compensation Appeals Board. So the Paige versus Perry Soto lawsuit, while it had the very best of intentions and intended to create some reform in the system that eliminated not only gender bias, but which required us to take a look at all other forms and aspects and circumstances and manifestations of bias, it was shut down due to a lack of jurisdiction at the particular court where the lawsuit was filed. So in 2017, this lawsuit basically faltered and stumbled. And it brings us to the point in time where we are today, and this is being recorded in 2021, where the Division of Workers' Compensation has recognized that there's a problem with bias. They've recognized, indeed, that there are copious examples of gender bias in the provision of benefits to injured workers, and the Division of Workers' Compensation is aware of the problem. And now this problem has risen to the top of the desk, to the top of the pile at the Division of Workers' Compensation, so that they must now address it. And the Division of Workers' Compensation now in 2021 has put forth some proposals in the form of new proposed regulations as to exactly how they plan to address this concern, this situation of rampant bias in the workers' compensation system. And not just bias against gender, but all other targets of bias as well. So in our next session, I'll share with you the Division of Workers' Compensation's plan to combat bias in the medical legal evaluation. And their plan is very, very comprehensive, is very, very thorough, and it encompasses the entire lifespan, I should say, the entire career span of a qualified medical evaluator, from even before a prospective doctor sits for the QME examination. Those doctors are going to be undergoing training and anti-bias training all the way through the career of the qualified medical evaluator until such time as that qualified medical evaluator declares himself unavailable or retires or in some other way discontinues his work or her work as a qualified medical evaluator. So it's a very, very comprehensive plan which is going to be upon all of us very, very soon. So it's important that you understand and that you buy in to the division's message that we need to eradicate stereotyping and biases in the provision of opinions and conclusions, so that all persons, regardless of gender, regardless of race, regardless of national origin, regardless of religious affiliation, regardless of sexual orientation, can receive workers' compensation benefits that are accurate, And nobody in the system has any problem with accuracy, and I, for one, am all for it. And that's why I'm sharing this material with you in this program with you. So that concludes today's session. I look forward to being with you on our very next session as we continue our ongoing discussion regarding combating bias in the medical legal evaluation. For now, this is Dr. Perry Carpenter. I'm wishing you best of success in your career as a qualified medical evaluator.